With regards to the executive session you're going to go into right now, can you be more specific about the litigation issue? Is there litigation in progress? Or I think you have to state what the litigation matter is.
No, you don't.
What's that?
No, you don't. And I'm not going.
I think you did.
Well, I think I
I
do.
think there's case law on that. I think there's case law on that, Jen, and I think I would check it if I were you. It's Title 65. Okay?
Title 65. What's that? The second place?
No, it's called the Sunshine Act.
I'll be happy to look at
Go
it.
check it out. I mean,
I'll be happy to look at it. If I'm wrong,
it's in the 700 series, so I think I got it on that one.
Okay. And Jim, if you didn't get me, will you apologize?
No, apologize. Who am I going to apologize for? You're the solicitor. I mean, I hope you got a
Well,
big
then I'll get a chance to say I got you then.
Okay. There is case law for the purpose of that you don't want me to talk about, so I think you can check that out. Be good.
Okay.
At the last meeting, I guess looking at the minutes under other business, at the last meeting there was an inquiry about the executive session you guys held after the meeting. Remember that? There was. I think Jim knows, because Jim and I went back and forth about what was the proper announcement of that meeting and the content and everything else. Right? Yeah. Could you guys be more specific about what that executive session was?
Absolutely.
Absolutely not? Okay. I would reference you then, Jim, to the code, the Sunshine Law Act, and also to the Reading Eagle Company versus the Council of Reading, Pennsylvania. I made a copy of it that says just that certain matters can be discussed by government bodies. Nonetheless, it also grants the public a right to know what matters being discussed. This is number 1 on PA. Actually, this would be on page 340 of the Sunshine Act.
Just give me a section, Jim. Your page.
Section. Well, this is section 708 and the decisions, number 1. The Act requires that reasons for public exclusion from executive session be given so that the public can determine who is properly being excluded. Reasons stated by the public agency must be specific, identifying a real discrete matter that is best addressed in private. When a closed executive session is called by an agency to discuss complaints or threatened litigation, the general nature of the complaint must be announced. That's number 1. Number 2.
I don't know what you're reading from, Jim. You're not reading from the Act.
Well, I'm reading from the pertinent statute that gives the actual notice of decision. So, also the Sunshine Act also requires it to reveal, when announcing an executive session, the names of the parties, the docket number of the case, and the court which is filed. Yeah, I'm good.
I appreciate it because that's not in the Act.
I would suggest you read that and familiarize yourself with that, because I believe you're in violation of the Sunshine Law, and it's been 28 days since you violated the law. I would suggest you reevaluate your position. Thanks. Jim? I'm going to use the mic. I agree with Bill because you can't hear anything. Just one thing, Jim. The thing that I did give you came out of pertinent statute, and this, what we're talking about with this situation, has been adjudicated already in common pleas and upheld in Commonwealth. So, what we're talking about has already been decided. So, I appreciate you to read that, because, and you get back to me or let me know, because, you know, the infraction occurred 28 days ago. I mean, all right?
I'll take a look at
Okay.
what you quoted to me is not in the Act, it's in the case.
Right, well, the courts have interpreted what the Act says, and it's right there for you, so, okay, thanks.
But I guess it's back to the when the executive sessions were announced. Way back when Dr. Mollick made a point saying that you guys aren't announcing executive sessions in the correct manner. There was a discussion about going back and forth, and I guess we said that we'll rely on Mr. Garrity's expertise. He's a lawyer, he's a doctor, he knows what he's doing. And I guess in retrospect, looking back on it, were we doing it in the right way, speaking about the executive session? Were we announcing the proper way?
It's
Exec question.
Yeah.
All the way back, and as early as I can remember Dr. Mollick being here, he questioned whether an executive session for litigation should include some specificity about the litigation in question. And I took the position, I believe initially, that specificity was not necessary after reviewing the Sunshine Act. Dr. Mollick, however, was correct, and I think I've stated he was correct, that there is a case interpreting the Sunshine Act called, I think it's called Reading Eagle. It's the newspaper in Reading versus some school district, I think, which says there must be some specificity in identifying litigation so that the people can be assured that it's not a false executive session. So as soon as Dr. Mollick pointed that case out to me and I saw it, I changed my advice to the township, as the board knows, and said that it is necessary to provide some specificity on the litigation being discussed when you have